Let's start with the introductory slide. The BELA Bill stands for the Basic Education Laws Amendment Bill. This is a bill that proposes to amend the SA Schools Act. So although there have been many BELA bills over the years, this is the first major revision of the SA Schools Act since it was promulgated in 1996, and it will probably influence the future for many years to come. That's why this bill is so important. This is a quick overview of the process that the bill goes through. So a bill starts with a minister that starts to draft a proposal to amend a law. So the minister appoints a task team that will draft the law to realize certain political intentions. This task team then follows a process known as the pre-parliamentary process. So this process started in 2013 already until it was submitted to Parliament. So when the bill is ready, the minister then tables it at Parliament, and then it follows a parliamentary process. And that's why where the bill is currently, it's being considered by Parliament, and you'll see the little indicator there. After Parliament has approved the bill, it's then handed to the President for signature. When signing the bill, it becomes law, and then the President will also determine when the law comes into force. And then after the bill has become law, the minister will start promulgating regulations in terms of the law, and the regulations will determine the details of how the law is enforced. So that is on a high level how a law is born. Now, currently we are in Parliament, and this is a quick overview of the process it follows in Parliament. So the BELA Bill has to go through two houses, the National Assembly and the National Council of Provinces. So the bill has already gone through the National Assembly, and it's currently in the National Council of Provinces. And I assume most of you have been through all the submissions for the National Assembly and the public hearings. Now the bill follows a similar process to the National Assembly, meaning there will be written submissions, there will be oral submissions, and there will be public hearings in the provinces. But now, despite the fact that the majority of people rejected the bill, the National Assembly still passed the bill in October 2023 and handed it over to the National Council of Provinces. Now, this is a quick overview of the process it follows in the National Council of Provinces. So in the provinces, you've got the Select Committee. The Select Committee called for written comments by 19 January, but then they extend the closing date to the 31st of January. And now the provinces are having public hearings. Mpumalanga had already had a round of that, and all the hearings will mostly be in February and March. So that's a quick overview of the process. I see Stacey wants to come in. Okay, now Home Educators has got two types of objections against this bill. That we call them procedural and substantive objections. Procedural objections refer to objections about the process that was followed to draft the BELA Bill, and where the substantive objections refer to the content of the BELA Bill. So one about the process and the other one about the content. So firstly, let's look at the procedural objectives. The first one is stakeholders were unable to consider the impact of BELA Bill. Now, for every policy or law, a socio-economic impact assessment has to be done to describe to those that must consider the bill what the impact of the bill is. So this was done for the BELA Bill. When the BELA Bill was published for comment in 2017, the socio-economic impact assessment, or in short, SEIA, was not published, was not made available to the public to comment on. So when you consider a bill, you must look at the bill itself, but also on the SEIA. But the public couldn't comment on the SEIA in 2017. In 2022, again, when the National Assembly published the bill for comment, it was again published without the SEIA. However, the Pestalozzi Trust did obtain a copy of the SEIA. And if you read the SEIA, you see it refers to 3 appendices. And Appendix C is about the impact on home education. And when you look at that, you see that appendix was not distributed to the National Assembly or the NCOP. So not even the National Assembly had that appendix, let alone the public. That's okay. So that's the first problem. The SEIA wasn't available to comment on. Secondly, if we look at the SEIA itself, it's got some major flaws when it comes to home education. Firstly, it doesn't look what is the impact to the state to provide a registration and assessment evaluation service at acceptable service level. Yet to process all the registrations, to check all the assessments that they want, requires a lot of people that will have to give an acceptable service. The costs of that haven't been looked at. Secondly, the BELA Bill prescribes the educational programs that home educators must follow. They haven't considered what this restriction of choice, what impact that will have on the home education sector. Furthermore, the BELA Bill restricts the venue where you can give the home education. They've also not considered the impact of that. Thirdly, the BELA Bill prohibits the use of tutors. They haven't considered the impact of that, as well as the costs associated with using competent assessors. So the BELA Bill impacts home education, but that impact hasn't been considered. Now we'll look at the substantive. That means what is wrong with the content. Firstly, clause 35 of the BELA Bill allows the head of the department to set aside the decision of parents. Now, I assume you all know to decide to choose home education is not a decision you take lightly. And in order to make that decision, you have to consider many things except apart from education. Further, you as a parent have got the right to choose home education. But Clause 37 gives the head of department powers to set aside that decision. So by giving them the power to decline your application for home education, while the education department is not the upper guardian of your child, and they are not equipped to determine whether home education is the best interest of the children. These officials don't know your child. They don't know all the aspects that are involved in determining the best interest of your child. Secondly, Clause 35 outlaws education programs that are not comparable to the national curriculum. Clause 35 of the BELA Bill limits the right to education by adding an additional requirement that is not in the Constitution, by saying that the proposed home education program must predominantly cover the acquisition of content and skills comparable to the relevant national curriculum determined by the minister. This essentially outlaws education program of a standard that's the same or higher than the national curriculum, but covers skills and contents that are not comparable to the national curriculum. Secondly, Clause 1, that is the definition section, places a restriction on the places where you can educate your child. So it says home education must take place in the environment of the learner's home. This essentially outlaws the provision of an education program on the direction of the learner's parent in an appropriate environment outside the learner's home. For example, the situation where somebody is able to provide home education under his or her supervision in the workplace. Maybe a hair salon is a typical example. And it also prohibits collaborative home education, where families work together, and one day then one person's home and the other day then the other person's home. Such a restriction is not in the interest of all children. Fourthly, Clause 1 restricts the use of tutorial or educational support, because it says that home education may include tutorial or other educational support if necessary, secured by the parent on specific areas of the curriculum followed by the learner. This essentially outlaws the use of appropriate tutorial or other educational support on all areas of the curriculum provided under the direction of the learner's parents. For example, it will prohibit the situation when parents use a family member that might even be a qualified teacher to provide all education to the at the child's home. So the Pestalozzi Trust has developed a proposal to address these issues. Now, in the CR, we read that the DBE, the Department of Basic Education, expects that home educators will not accept BELA Bill, and that there will be lots of disputes. And in the CR, the DBE in effect says they plan to resolve these disputes by means of mediation and litigation. So after they start enforcing BELA Bill, there will be disputes and there will be legal action. So in order to avoid such legal action, we propose an alternative formulation of Clause 35 that will protect the rights and freedom of home educating families and uphold the rule of law. So that is the first one, alternative formulation of Clause 35. But we also advise that the Parliament considers a fundamental review of the whole education system to make better provision, not only for home education, but also for many new emergent educational forms. Since 1996, the education landscapes changed from a unipolar landscape dominated by schools to a multipolar landscape consisting of a diversity of educational forms, of which home education is only one. Other forms include online schools, tutor centers, cottage school, collaborative home education, co-working spaces, etc. This was not only proposed by the Pestalozzi Trust, but many other stakeholders made similar requests to Parliament. So this slide. You can see this is the proposal. This is an alternative formulation of Clause 31, or the alternative formulation of Section 51 for the SA Schools Act. So this the head of department must register the child, but the head of department is not allowed to set aside the decisions of parents to choose home education. So that is the essence of this. If the head of department believes for some reason that choosing home education is not in the best interest of the children, then they can investigate the case. And if they want to set the side of the decision of parents, they must then approach the courts to do that. But they cannot do that. Only the courts can do it, because they're the upper guardian of the child. The benefits of this proposal is that it realizes the purpose of the bill. There was some uncertainty in the current Schools Act, that it says you may register. This alternative formulation says you must register, just like the BELA Bill does. But it does not usurp the powers of the courts to be the upper guardians of the court, the upper guardian of the child. It gives a clear roadmap, because they've often got problems. But what must we do if there is a problem? If it's home education, there are rare cases where home education is not in the best interest of a child. It gives a roadmap of how to handle those cases. It doesn't limit the right to education, as we said in our substantive objections, and it's designed around the exception. So we accept there are exceptional cases where home education can be used as a smokescreen for child neglect, but this solution protects the children concerned by putting measures in place that address the exceptions without placing an unreasonable burden on the majority. So now we come, that is sort of objections and solutions. Now we come to a proposal of how you can structure your submission. Firstly, when you do your presentation at the public hearing, give a brief introduction, 2 sentences of how long you've been homeschooling, what your reasons are. This is just to establish you as authentic and an authority on your subject. It's not there to sell home education. They know all the story of how good home education is. So keep this very short. Then you can mention that BELA Bill was rejected by the majority in previous public participation, in the public hearings and in the written submissions. Then you can choose the procedural objections that you feel strong about. So it's the procedural objections about the CI that I explained. It's also the procedural objections about regulations. I think I skipped that point in that slide. So the problem with the regulations, I'll quickly explain, is that the BELA Bill in its current form gives the minister unlimited power to make regulations. It doesn't limit the power of the minister at all by using broad terms that can be, it can mean anything. And that is a problem. How can we, if the minister, how can we give the minister the power if the minister doesn't tell us how the minister will use the power? So that is the problem with the regulations. Then we've got the substantive objections, which explains that it gives the HOD powers to set aside parental decisions. It restricts the right to education, to choose curriculum, to choose the place of education, and to choose tutors. And then you can give a proposed solution. Maybe you've got some solution that you think is good, or you can say you like the Pestalozzi solution, or one of the associations. The Gauteng Association did a lot of effort to formulate a solution. So you can decide what solution you want to put forward. Or you can say the BELA Bill must go back to the drawing board to educate, to accommodate new educational forms such as online schools, etc. And then you thank the committee for listening to your submission. And all of these things you must say within, I think, 3 minutes. And then the technical detail, written submissions must be in by tomorrow, by 4 o'clock. Templates are available on the Pestalozzi website. So those are very handy templates that will explain exactly how you can compile your written submission. And we've also created channels that if you are not able, or you don't want to write something, you can always send a voice message or a video message to a WhatsApp number or a Telegram number. And we've made arrangements that you can send your voice submission to us, and we will then put that on a memory stick and give it to the select committee. So in that voice message, you just begin your message by saying what's your name, your province, and your contact number, and then you give you tell your stories. Also keep it less than 5 minutes. Then there will be public hearings in the provinces in February, March 2024. And those details have been shared on the WhatsApp group. So here, I'm not going to go through them. On Mpumalanga was already, the first round was done, but I heard there's now a second round for Mpumalanga. KZN starts the 2nd of February. Gauteng, we're not sure. We heard about those days, but there's no certainty on that. Free State is starting the 13th of Feb. Northwest does everything on the 2nd of Feb. Limpopo starts on the 5th of Feb. For these public hearings in the province, you can also submit written submissions as well, and in these things we also add the email addresses to which you can send that. This is just a graphical illustration of where the different hearings are, and that's it. So now I'm gonna stop recording.